We'd like to welcome you and thank you for joining us. We're going to chat with you for the next few hours on our seminar, which Employers Practice Makes Perfect. Let's turn it over to the first program, which is the departing employee, which is presented by my colleagues Nancy, Mari, and Allyson. Thanks.
I am Nancy Ramalho. I'm a partner in the Labor and Employment Group, and along with Maimets and my colleague Allyson Marta, we're going to be talking about the departing employee. So I hope everyone's logged into the poll because I'm about to switch the slide. All good? Okay. So today we're going to be talking about is the departing employee, and we're going to look at a series of topics. Is the employment contract helpful? Always our starting point. What is common law notice? What constitutes total compensation? What are the options for structuring this payment? And then another bucket that we call everything else, which is a little bit of everything. So we thought it really helpful, because we live in the real world and real facts arise. We thought it'd be helpful to put this in the context of a fact scenario. So Mr. Matthews is a regional sales manager for ABC Co. He has 7 years of service, and he's 64 years old. He was originally hired as a salesperson, and at that time, he signed an employment contract. He was promoted in January of 2017 to a regional sales manager. His performance as a salesperson was great, but his performance as a manager left a little bit to be desired, and he demonstrated bad judgment on off hours. His compensation included base, commission, bonus, LTIP, and vehicle allowance. He participated in the company's DC pension plan and a benefit plan, which included a healthcare spending account. He had a strange relationship with his supervisor. He thought he was a superstar and perhaps should get the C on his captain jersey, but did not get that. So let's look at our employment agreement. So Mr. Matthews' agreement provides for a termination provision, which we're going to review, a new commission structure, which was agreed to when he was promoted, or a new bonus structure that was agreed to when he was promoted, bonus language in a side letter, and you're going to see all of that. His agreement does not provide for any restrictive covenants going forward or post-employment. So first step, we always say when thinking about getting rid of an employee, you want to think about what paper do you have. So looking at the employment agreement, is it enforceable? For those of you who have been in our sessions before, you know that the first step is, was there consideration given? So was the agreement signed prior to the commencement of employment? What was signed when he was promoted? Was there a new agreement entered into? Was there an agreement that said all terms and conditions will continue post the promotion? In this case, the agreement was signed prior to the commencement of employment, so we have a valid initial agreement. The issue is there was nothing signed after the promotion or in conjunction with the promotion. So there is a question of consideration. It's a good practice tip that as we promote people, because as you all know, employment agreements change all the time. The language, what may have worked 5 years ago no longer works now. The law is constantly evolving. So it's a good idea as you promote people to look at the paper that they've written and to see whether or not there's something we can improve on, and how do we, if it is good, how do we make sure that it still survives? So this is the termination provision that's contained in Mr. Matthews' employment agreement. And you'll see that there are some issues. First of all, it's far too general. It's easy to get into the trap of trying to do a one-size-fits-all employment agreement that suits, for those of you who are national, that suits across Canada. It's harder to enforce those types of agreements. So in this case, Mr. Matthews works in Ontario. There's no provision for severance pay, so there's your first catch. It says that it's going to continue benefits for the minimum period provided under the ESA, or the applicable employment standards legislation. We know that he had a car allowance, a pension plan, and there's no talk about commission or bonus and how that's going to be treated. And Mari will talk about that as we head on through this process. So in our view, it's unlikely that this termination provision is going to be enforceable. But for the purposes of your employment agreements going forward, or where we see some success in enforcing, especially ESA-only provisions, is a savings provision. We've been using them a lot, and so if you've received a new employment agreement for us, you'll see that it's part of our new standard template. And we think that it allows us the opportunity to fix any current law, or as the law continues to change, we hope to capture those changes. So this is a recent savings provision that was reviewed by the Court of Appeal in 2019 in the Andros decision. And you still have to be careful. In this case, what the Court of Appeal said was A and B are a little vague. Do they mean that you're going to continue the benefits during A and B? And so because of that vagueness, or because of that ambiguity, the court struck down the savings provision and the entire provision was gone. So that individual went to common law. Similarly, also 2019 Court of Appeal decision in Amber Burr, that per person, I keep mispronouncing his name. This savings provision, on the other hand, was found to be enforceable. And this is more in line of what we're seeing, which is a standalone agreement that allows the whole contract to be read up. So in this case, it would mean that the ESA provisions will now take over the provisions in the employment contract, and you'd have an enforceable agreement. So something to think about in terms of if you are looking at revising your employment agreements and you want to think about putting in termination provisions that you hope are going to survive the challenges of time, that a standalone savings provision might be your way to do it. Okay, so now that we've decided Mr. Matthews' employment agreement is unenforceable, he's at common law. So as you all know, having gone through this numerous times, what we look at and think about in terms of what constitutes common law entitlements, we look at the Bardell factors, and those are position, age, compensation, years of service, and then availability for alternate employment or a new skill set. In this case, Mr. Matthews' experience is limited to selling hockey equipment, and he's been a manager for less than 2 years. There are other factors such as inducement. We're not covering that, and otherwise Mr. Matthews would have a very difficult fact scenario for us to get through today. But those are the factors we're going to consider. And this is your first poll. So if you could, using your polling, can you let me know where you think he might fall within this fact scenario? Mm-hmm. Okay, so most of you think between 9 and 12 months. And this always takes a little while for everyone to actually register, but given that we're at say, 60% or 58%, we actually think it's closer to 10 to 15 months, and that's what the our websites or our databases are showing. And the reason for that is his age. So at 64, difficult to find a new job in a managerial position. So with 7 years of service, he's probably closer to 10 to 15, with some cases going as high as 18. Okay, so structuring the payment. So now you get to a point where he's entitled to 10 to 15 months of severance, and you want to think about how you're going to structure that payment. Because remember, this is not a golden handshake, contrary to plaintiff counsel's representations. This is not a guaranteed amount. This is subject to mitigation. So in the context of all of that, you want to think about how to structure this payment in a way that's going to work for you, that you can use as a bargaining chip, and so we're going to give you some ideas. You could start by making it a lump sum versus salary continuation, and there's lots of different reasons why that's appropriate. A lump sum, an employee will like it for the purposes of tax consequences, because he or she can roll it into an RRSP, versus a salary continuation that cannot be treated as a retiring allowance. You ought to remember again that it's subject to mitigation. So if you do salary continuation, you can do all payments cease upon him finding alternate employment. And the sweetener is what we call the clawback. So the clawback is, instead of all payments cease, you get 50% of the remainder. So again, let's assume for a moment we're using 10 months. Mr. Matthews finds a job in month 5. You would be giving him, he would have been on salary continuation for 5 months. All payments cease, and then you're giving him a 2.5-month sweetener. And what this does is it encourages an employee to go out and find work. Because if you're going to pay them a salary continuation with clawback and no entitlement, then there's no incentive to go out and find work and use that outplacement counseling that you've offered them. Instead, what they're going to do is they're going to wait around and start looking for work in the last 3 or 4 months. So in this case, it works a little bit. It's a bit of an incentive, and it keeps them going. So when thinking about lump sum, salary continuation, mitigation, sweetener or no sweetener, what are you thinking about? You're thinking about the fact that, to some extent, as I said, the employees like lump sums because they can use it. There are tax consequences that are beneficial to them. Just have to remember, if you are doing salary continuation, that an employee could require you to pay their statutory severance in a lump sum. You don't necessarily need to raise that in the letter. Once they've signed off and on the release, then they've acknowledged and agreed to the fact, but that could be a request that you can't deny. One thing we get a lot of challenges on is the definition of alternate employment, especially if you're providing a 50% clawback. So the idea being that all salary continues until such time as they find alternate employment, and then you get 50%. Well, an employee says, if I decide I'm going to go work at Walmart, I shouldn't be dinged for that. So sometimes we define alternate employment that where the employee can receive 50% or more of the current total compensation package. Yeah, again, the idea being that you're keeping them whole for a period of time and that they're earning 50% and you're paying 50%. That number is always a negotiation, or what constitutes alternate employment is always a negotiation, especially in our era of precarious employment and contract employment. Restrictive covenants. If there are written restrictive covenants, keeping them honest by salary continuation is a great way, because if they start to breach it or there's any indication that they are breaching it, you could stop payments, and it's sometimes a good way to kind of keep people honest. One other ask that we've been receiving a lot, and we typically get it, September, October, November, which is, if you're paying me in a lump sum, can you defer the payment to the following year? So in the case of Mr. Matthews, let's assume for a moment that we were going to pay him 10 months in a lump sum package, and we were prepared to defer income. Given the lateness of the year, you could continue him on salary continuation till the end of the year and then pay him a lump sum. Or depending on your risk tolerance, you could pay him his ESA minimums in a lump sum and then in 2019, and then pay him the remainder in 2020. So you can defer some income. We just caution you that there has to be some rationale behind it. And for instance, if this were January of 2019, I wouldn't be recommending deferred income. And then, as we talked about, there was a little bit of talk. Mr. Matthews is a bit unhappy with his supervisor. And so as we are seeing more and more of, you're seeing employees who start alleging harassment or bullying. And surprisingly, those only come in a demand letter after you've terminated them. So those types of kind of general damages, if you are going to allocate anything to general damages, you want to be sure that you have a reasonable grounds to do so. It's easy if there's a claim, a statement of claim that makes allegations of mental distress, then you can try and allocate towards generals. But if this is a regular negotiation and you don't think there's any basis for a general damage claim, then I would suggest that there not be any sort of allocation. And for those of you who don't know what general damages are, they arise from usually either mental distress or a human rights complaint. So at the Human Rights Tribunal, they'll get loss of wages and a general damages claim, and the general damages claim is tax-free. So that's the benefit. Sometimes if you want to allocate, and you can reasonably allocate, you can pay less, more in their pocket, and the only person who loses out on the tax man, and hopefully nobody in here cares about that, or I'm in a lot of trouble. Okay, so again, those are the options when you want to think about structuring. Again, if we think Mr. Matthews is going to be litigious, then we want to go in with a scenario that gives us some bargaining room. So in that case, it's salary continuation with a clawback. Because then what you can say is, instead of the 10 months that we've offered you in salary continuation, we're prepared to give you 10 months, but as a lump sum, thereby making it more attractive, or adding in the 50% sweetener, thereby making it more attractive. You're still not really increasing your offer, but you've given yourself some wiggle room to be able to think about it. So I would say that severance packages and designing a severance package is becoming a bit more complicated. And the reason it's becoming more complicated, especially in a common law scenario, is everybody goes to see a lawyer. And everybody comes in with either the top of the range or well beyond the top of the range with all these additional complaints that you had never heard about before. So from that perspective, giving yourself a little bit of room, or a little bit of positioning yourself in a way that allows you to negotiate something is very helpful. Okay. So then we are going to total compensation, and Mari's going to take this over in terms of talking about what constitutes total compensation and what to consider when you're structuring that package.
So the reason that we're looking at total compensation is that Mr. Matthews is entitled to be made whole for the reasonable notice period. So let's just review his total compensation. He has a base salary of $150,000 a year. He's entitled to commissions. We know from our fact scenario that over the last 2 completed years of employment, so 2017 and 2018, he earned an average of $55,000 per year in commissions. But if we look back 3 years, we can see that he actually was doing much better than that before his promotion to regional sales manager. His average over the last 3 completed years was $75,000 a year. He's entitled to a bonus. In the year 2017, the year of his promotion, he was guaranteed a bonus equivalent to his base salary of $150,000, very generous. And then in 2018, he earned $65,000 in bonus. He's also entitled to long-term incentive compensation. We'll drill down on that a little bit. He has a vehicle allowance and a suite of benefits. So commission, we have 2 periods of time that we have to consider when we're looking at what are his entitlements on termination. The first period of time is the stub period from the beginning of 2019 to the date of his termination, so assuming that that's today, October 29th, 2019. And then we also need to look at the reasonable notice period. And the analysis is a little bit different depending on which period of time you're looking at. So the first step, as Nancy said, is that we look at the plan language itself. In this case, he's entitled to receive commission of 1% on new business generated by the sales team that reports to him, payable within 30 days of the completion of the quarter, in respect of which commissions are paid. So we are October 29th of 2019, which means that tomorrow, Mr. Matthews is entitled to his commission payment for Q3 of 2019. So that's something that he will need, he's earned, and he's entitled to be paid. And this question about when commissions are earned is one that courts will distinguish between when commissions have actually been earned and when they're payable. So the payable date we know from the plan language is within 30 days of the completion of the quarter. But because there's no guidance, no further guidance given in the plan language, we need to factor in that he's worked for a third of the last quarter of this year, and a court is going to interpret the lack of specificity in the plan language against the employer in Mr. Matthews' favor, which means that it's likely that in January of 2020, he will be entitled to earned commissions in respect of October of 2019. So that's what he's earned to the date of his termination. Now looking forward into the reasonable notice period, this is a little bit more of a hypothetical exercise, because the question that a court will ask is, what would he have earned during the reasonable notice period had he continued to work? So this is a little bit of a shot in the dark. Let's poll the audience. and see what commission Mr. Matthews is entitled to during the reasonable notice period. Our first option is looking back the full 3 years. Who thinks it's $75,000 per year? Our second option is the average of the last 2 years, so that's since his promotion to regional sales manager, $55,000 per year. Let's throw another one in there. Perhaps we can look at it on a quarterly basis. What are his average earnings over, say, the last 6 quarters? We, in our fact scenario, don't have a lot of visibility on what he's done in 2019, but that is an option. Or are we going to take the position he's not entitled to any commission? All right. The poll is closing in 3 seconds. Okay, so most of the room thinks it's $75,000 per year, so looking back a full 3 years. And I'm very thrilled to see that nobody picked the only wrong answer on the board, which is no commission. There is no language in the plan that would enable us to take the position that no commissions are payable. So as between the first 3 options, there's actually no wrong answer. As long as there's a rational basis for offering any one of those 3, we're able to negotiate. What we would actually recommend in this situation is that you pick the option that is most favorable to you in terms of a financial hit, and you start from there and expect that Mr. Matthews may negotiate the number, and then you can go back and forth and argue about it and arrive at something that everybody's equally unhappy with. So going back to the total compensation package, the next thing we need to think about is his bonus entitlement. So when he was promoted, he got a side letter that congratulated him and said, we're delighted at your promotion, and that in the year 2017, you will have a guaranteed bonus of 100% of your base salary, and that in future years, any bonus payments will be strictly in the discretion of the company. And actually, the language up there, ignore. It's guaranteed bonus in 2017, and then in future years, it's within the discretion of the company. And we know from our fact scenario, he got $65,000 for the year 2018. There's one last provision that says if you're terminated from employment, you will receive no further bonus. So a couple of considerations. Again, as with commissions, we need to think about what has he earned, if anything, for a bonus up until the date of the termination of his employment. And we also need to think about what bonus would he be entitled to for the reasonable notice period. Now, because of the language about discretion in these plan terms, it is open to us to consider taking the position that it is a discretionary payment and therefore he's entitled to nothing. Very aggressive position, risky because he's made such good bonuses over the last 2 years of employment that he's probably not going to take that lying down. And a court will not be satisfied with just the black letter of what's in the agreement. So the court will look at, has he ever missed a bonus year? Has any other employee in the company ever missed a bonus? And if the answer to those questions is no, you're going to be very hard pressed to stick with the position that he's not entitled to any bonus. So we have to factor in that he'll be entitled to something for the, having worked almost all of 2019. There's a couple of options for how we might arrive at a number, because we don't have very much information here. One option is to look at his past bonuses and average them out and pay him that figure. Or if there's some evidence that we can point to that there's actually a formula that the company uses to determine the bonus, for example, performance metrics, maybe we look at his performance metrics and see how he's done and base a number on that formula. Or third, and this kind of bleeds into our analysis of what we would do during the reasonable notice period as well, is we look at comparator employees, what have his peers earned in the year 2019, and we pay him based on that. Now, during the reasonable notice period, the question of whether he's entitled to a bonus is subject to a couple of key questions. Number one, is there an express contracting out of the bonus entitlement during the reasonable notice period? And here we have some fairly vague language saying if he's terminated from employment, he will receive no further bonus. Unfortunately, that language is too vague to be of much help to us. It doesn't expressly say that you're not entitled to a bonus payment in respect of any common law notice period. So unfortunately here, we have exposure to a bonus for the entire reasonable notice period. The other question is, can we fall back on the discretionary argument? And the answer to that is probably not, because it's a very integral piece of his compensation. He earned 100% of his base salary only 2 years ago. So he's very likely going to be found entitled to a bonus during the reasonable notice period. And here again, how do we calculate that? It's basically those same three factors. We look at either an average of his own bonus earnings, we compare him to his peers, or we look at whether there's some sort of performance metric and some sort of pattern of achievement that we can point to as to assist a court in figuring out what he would have earned during the reasonable notice period. I'm just going to touch very briefly on long-term incentive compensation. The question here is really, after the date of termination, is he entitled to ongoing vesting of any awards that he's been granted but that haven't actually come to fruition in the time that he was actively employed with the company? And this is going to be a very strict exercise in interpreting the language of the plan. So we're not going to spend a ton of time on this, but if you ever are in this situation, we encourage you to give us a call because it is a contractual interpretation issue. So here, the language says that if his employment with the company terminates for any reason, any options held by the employee that have not vested before the effective date of such termination of employment shall terminate immediately upon such termination of employment. A court will interpret termination of employment to mean lawful termination of employment, which means taking into account his common law notice period entitlement. So unfortunately for us, this language doesn't expressly contract out of common law ongoing vesting during the common law notice period, so we're stuck probably recognizing the vesting of his awards during the common law notice period. And just a tip about the use of electronic systems. So more and more we're seeing the granting and exercise of equity awards being done using electronic systems. Some of these are more sophisticated than others, and typically when an equity award is made to an employee, all of the contractual documentation is referred to in hyperlinks that they can click on, that they may have to sign off on, but the system itself doesn't necessarily always record that they've actually affirmatively accepted the grant agreement that governs the award. And so what we run into is when sometimes these matters go to litigation, we find ourselves without the evidence to show that they actually were referred to the document that we say binds them. So what we would recommend as a key takeaway from today is that if you're using electronic systems, still try to get hard copies of your plan documents and your template grant agreements into the hands of your employees before they accept the grants, because then it'll be much harder for them to argue that they didn't know what they were getting into. So to speak about the next piece of the total compensation package, which is the continuation of benefits, I'm going to turn this over to Allyson.
So pensions and benefits form part of an employee's overall compensation. As such, there may be terms under the pension and benefit plans or circumstances related to the party employee that are relevant to how benefits continuation is structured. In Mr. Matthews' case, he has a pension plan and group benefits. But we also know some potentially relevant personal facts. The fact that he's 64 years old, he has 7 years of service, and he's had numerous shoulder injuries. The specific concern with the shoulder injuries is that if his benefits are terminated and he becomes disabled during the reasonable notice period, there is a risk the employer could be liable for long-term disability benefits. Benefits coverage usually requires that an individual is an employee, and 65 is typically when coverage ends under long-term disability plans for active employees. As such, given that Mr. Matthews is 64 and may make an LTD claim, it may make sense for salary continuance until at least 65 so that he can maintain his LTD coverage. If he has a defined benefit pension, salary continuance until 65 provides the added benefit of continued pension accrual until his unreduced retirement date. Note, however, that you cannot require him to start a pension. You would have to agree. Since Mr. Matthews only has 7 years of service, the value of any pension to the end of the common law notice period, depending on how long it is, may be of greater interest to him than starting a pension at 65. Having said all of this, if for some reason salary continuance is not the preferred approach, other arrangements for pension and benefits continuation would need to be made. With respect to Mr. Matthews' long-term disability and other health benefits, it may be possible to make arrangements with the insurer to continue his coverage after the statutory notice period, even though his employment has terminated. Insurers will generally agree to this, although not typically over longer periods. In this case, the benefits would only need to be maintained until he is 65 to address concerns regarding his LTD coverage. And since he's only 64, such an arrangement with the insurer seems like a possibility. With respect to other arrangements for Mr. Matthews' pension entitlement, it's worth noting that amounts paid as retiring allowance or general damages, which Nancy pointed out are options for payments, are not employment income for purposes of the Income Tax Act and are therefore not pensionable. Additionally, the Income Tax Act imposes other limitations on pension accrual, such as money purchase annual contribution limits, or in the defined benefit context, the need for service to support the benefit accrual. These pension-related limitations would need to be factored in to any arrangements that are not structured as salary continuance. With respect to his healthcare spending account, any plan terms specific to treatment of account allocations and forfeitures on termination of employment should be reviewed. Let's assume that under Mr. Matthews' healthcare spending account, claims must be made within 90 days of termination of employment, or amounts will be forfeited, whereas for ongoing employment, they have 12 months to make a claim. These differences should be communicated to Mr. Matthews. With respect to his life insurance coverage, his plan provides for conversion to an individual plan. This conversion option and any relevant timeline should be communicated to Mr. Matthews at termination of employment, even if they've been previously communicated, for example, the policy document or employee booklets. Note that because of Mr. Matthews' age, his conversion options may be impacted under the plan term. The plan terms may provide for reduced coverage or no coverage at 65. For his other benefits, once his termination date is determined, plan terms should be similarly reviewed to confirm timelines for coverage and making claims after termination. These timelines should be communicated to Mr. Matthews, and these communications will often involve coordination with your benefits provider. In terms of takeaways for pensions and benefits continuation for the departing employee, it will be important to work closely with benefits providers, legal advisors, and where applicable, pension consultants, to develop an arrangement that addresses the particulars of your plan terms and any relevant individual circumstances of the employee. So I think I'm turning over to Nancy now to address the departing employee's obligations.
So if what you got out of the first half of this session was that assessing the common law piece was the easy part, and that putting together the package and all the relevant pieces was much more difficult, then we've done our job today. So you pay all this money to Mr. Matthews, and what are his obligations to you? Company property is surprisingly a really difficult thing to do. So the things we come across are, is the property company owned or employee owned? And Jackie and Lucy will talk about BYOD, so you'll get a sense of what that means, not being the technology person at all. And the scrubbing the device piece, yeah, don't ask me either. But apparently you can scrub a device remotely, so again, you want to be sure that those types of systems are in place. The other thing we come across is getting the passwords. So if it's a company phone and you don't have the password, you're going to incur a lot of costs in trying to fix that. So keeping records of passwords or getting the employee as part of signing their release to give you the password is also really helpful. And then in terms of a couple of tips, so using Mr. Matthews as an example, remember he doesn't have a non-compete or a non-solicit, but he's a regional sales manager, so he has lots of relationships with your customers. You want to see whether, you may want to see whether or not there's been any activity. Did he know he was going to be fired, and so he's already been transferring his customer lists to himself? You want to think about a risk assessment. So in that risk assessment, is it worth reviewing his emails or what is on his phone? Allowing their employee to keep their telephone number. Again, usually something that employers see as being a pretty easy give in a negotiation. The problem is, if he is a regional sales manager, all his employees all his customers are contacting him on his phone. And how do I prove solicitation if in fact they've all contacted him? They may not have known that he's already gone, and now we've lost the ability to argue that he's soliciting. And then the last thing is, we've had a lot of success recently in an application to return company property. So if you are having issues in getting your company property, laptop, phones returned, there is a relatively easy way to do it now. I would caution you that it has to be pretty straightforward facts, meaning there's no doubt that it's company property, there's no doubt that the employee has it. So when you swear that affidavit, it has to be pretty clear, and then it is a relatively easy application to do. Okay, because we only have, as Lorna's told me, 6 more minutes now. We talked about the fact that Mr. Matthews has no restrictive covenants in his contract. So we want to think about a couple of things. Confidentiality of the settlement terms, as you all know, really easy to enforce now, and the courts are being pretty harsh with the employees who breach these terms, whether it's by Twitter or Facebook, any sort of social media. So having those types of terms is a great idea in terms of ensuring that the employee doesn't spread around what he or she is being paid or the terms under which he's being paid. In Mr. Matthews' situation, we're talking about fiduciary, because he doesn't have any contractual obligations. So assuming for a moment he is a fiduciary as a regional sales manager, he has the obligation not to compete unfairly. What does that mean? It doesn't actually mean he can't go to a competitor, but he can't use confidential information, and he can't solicit customers for a period of time. So you may want to think about whether you want to put that in your termination letter. We sometimes say we'd like to take this opportunity to remind you of your obligations that survived the termination of your employment. And then this question we get asked a lot of is whether or not you can impose a non-compete or a non-solicit. After all, I'm paying him 10 months. Why can't I get him to sit out for 10 months? There's no garden leave concept like there is in the UK, and you can't impose a non-compete or a non-solicit unless you pay more than the common law entitlement. So you're already paying him 10 months, you'd likely be paying him an additional amount in order to compensate for there being or to buy the non-compete or the non-solicit. Going to a release, the top 3 things are, if you don't have it in an employment agreement, no matter how much you're paying that individual, you can't ask for a release. You'll have to pay something over and above what's in the contract. Think about a non-disparagement clause. Again, pretty standard in our world in terms of putting a non-disparagement in a release. We're getting lots of requests for a mutual non-disparagement. I'd challenge any one of you to ensure that you can represent that the company can't disparage someone. Given if you have 100 employees, that means you're advising that 100 of your employees are not going to disparage the employee. So my recommendation is always first to deny, and if it still becomes a stickling point, then agree to a number of individuals, named individuals, who you then send an email to, and you say, we have an obligation not to disparage, we're reminding you of this obligation. And in the release, it's not this employee will not disparage, but the company will advise this employee not to disparage. So at least you're fulfilling your obligations. And then going back to our general damages, if you are going to award general damages, there are provisions in respect of indemnifying for any sort of taxes arising from that award. So you want to think about whether you want to put that in your release as well. And then lastly, we want to end up with something that we get lots of little questions about, but sometimes very panicked questions because, oh my goodness, it's past 7 days and I haven't issued a record of employment. Am I in trouble? I would say, notwithstanding the fact that that is a statutory requirement, 99.9% of employers don't do it, especially when you're negotiating a package, because the end result is you issue one record of employment, you negotiate a package, you're going to have to send a revised record of employment anyway. So that's one thing to think about. Responding to requests from Service Canada, you have an obligation to disclose everything to Service Canada. Sometimes I find the easy approach for these requests is just to provide a copy of the termination letter or the minutes of settlement, because that'll explain what's going on. And then lastly, if you are doing the negotiations on your own and a period of time has passed, you want to ensure that that employee hasn't received EI, because if they have received EI, you are required to wait for an overpayment letter before you release any amounts. Otherwise, you could be liable as a company for the overpayment amount.